Welcome, dear followers and non-Arabic speakers, to the MT channel. In this series of videos, I will explain the labor law and all its provisions in English in order to help all non-Arabic speaking workers and employers understand the labor law and protect their interests. These videos will be posted every Friday of every week. I hope you enjoy watching this video. Let's start now.
Labor Law. Part 3. Employment of non-Saudis. Article 32. Recruitment may not be carried out with the intention of working without the approval of the ministry. Article 33. A non-Saudi may not practice work and may not be allowed to practice it unless he obtains a work permit from the ministry according to the form prepared for this purpose. Requirements for license. 1. The worker has entered the country in a lawful manner and is authorized to work. 2. Must have the professional qualifications or qualifications required by the country, not met by its own citizens, or the number of them does not meet the need, or be the category of ordinary workers needed by the country. 3. To be contracted with an employer and under his responsibility. The term work in this article means any industrial, commercial, agricultural, financial, or other work and any service, including domestic service. Article 34. The work permit referred to shall not be exempted from any license or license required by another person to practice the work or profession. Article 35. This article was amended by Royal Decree No. M/46, dated May 6, 1436 AH, to be as follows. The ministry may refrain from renewing the work permit when the employer violates the criteria for the resettlement of jobs established by the ministry. Article 36. The minister shall determine, by virtue of a decision, the occupations and businesses that are prohibited by the non-Saudi. Article 37. A non-Saudi contract of employment must be written and fixed. If the contract does not specify the duration of the work permit shall be deemed as the duration of the contract. Article 38. The employer shall not employ a worker in a profession other than the profession prescribed in his work permit, and a worker is prohibited from engaging in a profession other than taking legal action to change the profession. Article 39. This article was amended by Royal Decree No. M/24, dated December 5, 1434 AH, to become the following text. 1. It is not permissible, without following established rules and procedures, to leave the employer working for third parties. The worker may not work with another employer, the employer may not employ another worker, and the Ministry of Labor inspect the facilities, which are seized by its inspectors, and then forwarded to the Ministry of the Interior to apply the penalties prescribed thereon. 2. The employer may not leave his self-employed worker. The worker may not work for his own account. The Ministry of the Interior shall control, stop, deport, and punish the offenders on the self-employed, bulk labor, in the streets and fields, employers and operators of these and the sterilized and the carriers, and all those who have a role in the violation and the application of sanctions against them. Article 40. 1. The employer shall bear the fees for bringing in the non-Saudi worker, the residence fees and the work permit and their renewal, and the consequent delay of fines, professional change fees, exit and return, and the worker's return home after the end of the relationship between the parties. 2. The worker shall bear the cost of returning to his country in the event of his incapacity to work or if he wishes to return without a legitimate reason. 3. The employer shall bear the transfer fees for the worker who wishes to transfer his services to him. 4. The employer shall pay the expenses of processing the worker's body and transferring it to the contracting party or the worker, unless he is buried with the consent of his family within the kingdom. The employer shall be exempted in case of the obligation of the General Organization for Social Insurance. Article 41. The regulation shall specify the conditions of recruitment, transfer of services, change of profession, and the rules and procedures thereof.
By the end of this video, you should have increased your knowledge of labor law by now, and I hope I explained it to you by the right way. If you have any questions or inquiries, please write to me in the comments, and do not forget to hit the like button, subscribe to the channel, and activate the bell button so that you will receive all notifications when I publish the next video. Thank you all, and see you soon.